As Ms. Barragán from California for 5 minutes.
I heard the comment that the fact that only 20% qualify for asylum means that there's an abuse happening. One of the reasons it could be so low is because these people are not entitled to counsel. And as I mentioned, it is very hard to meet the legal requirements. You almost cannot increase the standard. It is already so high. I actually believe if we gave people counsel, you would see that 20% number increase, and by quite a bit. And so I'm not sure, I don't think the logic follows that because only 20% are granted asylum, therefore there's all these abuses. Having been in the system, having litigated asylum cases, I know firsthand how challenging it is, and I know the difference it makes when you do have counsel. Most people who don't have an extremely difficult time because it is so high. I want to go back to the issue of, I think, Mr. Cessna, that you had mentioned. How does USCIS determine a person's asylum claim is fraudulent? Like, how is that assessment made?
Well, the person could just be ineligible, flat out ineligible. That's different from being fraudulent. Both things are happening, and
yeah, I want to know about the fraudulent.
Right.
How do you guys determine if an asylum claim is fraudulent?
I think if the person says something that manifestly does not conform to the facts on the ground, we would determine that the person was lying and therefore made a fraudulent claim.
Do we have any numbers about how many were actually fraudulent under that definition you just explained?
No, we don't have any numbers on how many people are making fraudulent claims either in credible fear or in regular asylum yet, but we're working on that.
Do you have any numbers on how many asylum claims were denied by USCIS in recent years that have led to perjury charges?
No, I don't have that available.
Could you get those to me in writing?
Sure.
If you could, that'd be great. I want to also touch upon the incident that occurred, the Montana incident. The CBP has about a 100-mile radius of jurisdiction where you can, engage with somebody, pull somebody over for reasonable suspicion of an immigration violation or crime. Is that correct, roughly?
Roughly, yes. The court, through case law, has given us jurisdiction to do a number of things near the immediate border, loosely defined at 100 miles.
And if you take a look at the map, like most of Los Angeles alone is in that because of the West being on the coast, correct?
I think that's true for a number of coastal states.
How often would you say a CBP officer is going to engage with somebody and start questioning them about their status just because they're speaking Spanish? How often do you think that's happening?
I don't think it happens very often at all. I think that they're trained to do a number of things and look at a number of factors before they make an encounter, they make a stop for someone. In this case, it was roughly 40 miles or so from the border.
Okay, so should I advise my constituents that are within 40 miles of the border, they shouldn't be speaking Spanish anymore?
No, I wouldn't do that.
Okay, what advice could you give? Because look, I speak Spanish. It was my first language. It's actually an asset in this country to be able to speak two languages, especially Spanish. So there's a shortage of actually workers who employers seek to speak two languages, and Spanish is often one of them. I get questions now of, well, does this mean I shouldn't speak Spanish anymore? As somebody who's at CBP, what advice do you think I should give them?
I'm not sure. A number of social engagements. I've worked on the border for many years. I speak Spanish myself. It's not something that people should be concerned about if they're here illegally. And
in this case, the people actually showed ID, even though they didn't have to, and they were still detained for another 35 to 40 minutes. What is, in that case, what is somebody supposed to do? You've shown your ID, you're still being detained.
I would like for our Office of Professional Responsibility to do a complete review of the incident, and then I'm happy to come back or put in the record, if it's done by then, the total circumstance of that case.
Okay, if that happens to somebody, are they allowed to pull out their cell phone and just start documenting that they're being withheld for, 35 to 40 minutes or whatever it is?
Our agents are regularly filmed in the performance of their duties, and CBP has made an investment in changing policy and allowing for us to use incident-driven video recording. So we're going to be investing in and deploying a number of cameras in the workspace. Some of those will be actually worn by agents.
And agents are not going to delete the videos, right?
There's a whole policy that surrounds how we use the video and how it's stored and collected and et cetera.
Great. Thank you. I yield back.